We have a lot of issues to get through on our non-jury days for the next few days. Take the easy ones first. The state's motion in limine about overruling whatever objection the defense might ever offer to evidence on the basis of 403 waste of time and the defense response in opposition thereto. I am ruling for the defense on that one for all of the reasons stated in Mr. Weinstein's response in opposition. Takes care of that one. The motion in limine by the state to revisit the court's ruling excluding State's Exhibit 52AY. I have considered that, and I will not be changing my ruling on that. The couple of uncharged post-indictment intrinsic acts that were still outstanding. I've got one question on the circumstance that involved Mr. Ryan and the fight. And I can't remember which co-defendant, but there was a co-defendant who entered a guilty plea and attested to a conversation having been had about protecting a YSL member in the jail and hurting somebody else. What was that about? Do y'all remember that? And did that have anything to do with this? Or were those unrelated?
That was before this.
Okay. All right. Okay. So the court has determined that neither the Ryan situation nor the alleged passing of Percocet to defendant Williams in court meet the requirements to be an intrinsic act. And so I am not going to admit either of those. And I've also reconsidered, thought again about my ruling out the Stillwell situation of some contraband being in his cell, and I'm going to stand on my ruling with regard to that as well. One question I saw in my notes, something about the search for Attorney Johnson, the search of Attorney Johnson's laptop, and something that defendant Williams had requested with regard to that. Can you, Mr. Steele, refresh my memory on what that was about?
Yes, can I have just 1 second?
Sure.
Your Honor.
Yes.
The court. Good morning, Your
Good morning.
Honor. Can I make a statement to the court without the prosecutors here and without the media, so it would be on a sealed record? And then if you believe it should not be sealed, obviously I will repeat it, or you can have Ms. Winfrey read it back. But I believe that in an abundance of caution.
Come on up.
Okay.
All right. I know that there are some things outstanding that concern Mr. Ryan, and there's been a request that that be handled tomorrow instead of today. That's fine. So I'll set that aside for now. I appreciate everybody submitting case law on the issue of whether the RICO conspiracy can be established based on an overt act that's not alleged in the indictment. Frankly, it's a lot of stuff to read, and since some of the submissions were late last night, or basically all throughout the day yesterday, I have not read all of that, so we'll take that up at some other time, and that's really more of an end of trial issue for us anyway. Okay. I think we're ready to argue and consider the motion in limine. What was it, 62, I guess? All right.
Your Honor, may I approach?
Yes. Thanks.
Your Honor, I just handed this honorable court and the parties, although I ran out of copies, I just gave it to Mr. Matthews. The case I cited in motion limiting number 62, Ebersole, E-B-E-R-S-O-L-E versus State. It's 371 Georgia Appeal, 520. It's in Division 1C as in Colette. It's 901 Southeast 2D, 572, a 2024 case. And Your Honor, what happened in our case previously, and I understand this honorable court was not with us, but the prosecution through ATF agent Racy was testifying. He was at one time with Cobb County Police Department, and he was the lead detective on a case against Mr. Jimmy Winfrey, and that is in Cobb County case number 15-9-2765. And he was asked by Prosecutor Hilton about a jail call. And the jail call had something to the effect of, when Mr. Winfrey comes home, he will be given a Porsche and $250,000. It was something to that effect. And Ms. Hilton then asked Detective Racy, within approximately a month from that time, that jail call that the jurors just heard, did in fact Mr. Winfrey enter a guilty plea? I objected. That guilty plea was vacated and found to be coerced by the Georgia Supreme Court in Winfrey, W-I-N-F-R-E-Y versus State, 304 Georgia, 94, 816 Southeast 2D, 613, 2018. And it says specifically in that case that that guilty plea is void, is null, and cannot be used for any purpose. We approached the predecessor judge, and he said he didn't know about that case. It's all on the record. It was at the bench. And I said, well, here's the site. And he said, well, I'm not going to read it. And I said, well, I'm going to cross him on it, and I'm going to subpoena the lawyers, and I put them on my witness list who entered that plea, and I have a certified copy of the Supreme Court opinion vacating it, and the predecessor judge said I couldn't do any of that. Ms. Hilton then came back to the podium and asked Agent Racy the next series of questions. Well, was that plea, for whatever reason, vacated, and a short time later did Mr. Winfrey enter a guilty plea? I again objected. I was not allowed to go into it. The essence of this motion, number 62 of Mr. Williams, is I believe that that's already a constitutional violation. So it has to be harmless beyond a reasonable doubt. Because
Was there any kind of instruction?
no, no, it was, I can't cross on it. Mr. Matthews can't cross on it. We were all barred. And it came out that way that Mr. Winfrey pled guilty. And this dealt with the April 26, 2015 tour bus shooting of a gentleman named Dwayne Carter. He's a phenomenal artist, musical artist, known as Lil Wayne. So the state gets that in. Now, the predecessor judge did keep out the indictment on my objection because the indictment names as co-conspirators, unindicted co-conspirators, Mr. Williams in that event, and it was a RICO count. The further objection was that Mr. Winfrey, he didn't really plead guilty. This is the most favorable Alford plea, and I attached it to Mr. Williams' number 62 that, that I have seen where the predecessor judge specifically, excuse me, not the predecessor judge, Judge Staley, it's S-T-A-L-E-Y, and it's Staley Clark, C-L-A-R-K, Cobb County Superior Court. She specifically acknowledges that this is not a guilty plea. This is a best interest plea. He's not entering admission of guilt. The Honorable Steve Sadow, which is Steve, S-T-E-V-E, and Sadow is S-A-D-O-W, was the lawyer. He specifically said that we are doing this just because it's been 5 years and Mr. Winfrey wants to get out of custody. And I attached that, and I have a certified copy of that Alford plea. Anyway, the way it came in was so wrong, and we had cases that we were citing to the predecessor judge explaining that a person who's not testifying, the fact that they pled guilty, people plead guilty for any numerous reasons, should not be allowed to come in against Mr. Williams and the others here. So going forward, I put this on this court, honorable court's radar, because it is my belief and understanding, and if it's not going to happen, that's great, that Mr. Kendrick has pled guilty to being in a criminal street gang, specifically YSL, when he was with Mr. Martinez-Arnold. Martinez-Arnold is going to be a witness, but he did not plead guilty to that charge. And it's my understanding that the state intends to have an exhibit, a certified copy of the guilty plea of Mr. Kendrick. And that should not come in against Mr. Williams or any of the other people here for the same reason.
Let me stop and ask the state, is your position that it comes in against anybody other than Mr. Kendrick?
I don't believe that a certified copy of Kendrick's conviction would be admissible against another defendant besides Kendrick. And additionally, we intentionally did not tender the certified for Jimmy Winfrey.
For Mr. Winfrey?
Correct. The court did not preclude us. We did not tender it.
Right. Okay, so is it the state's position that not the certified copy of the conviction, but the fact of Mr. Kendrick pleading guilty to, it was gang activity and the gang being YSL? What's the state's position on that with regard to that information coming in on anybody else?
I think that his guilty plea, the fact of his guilty plea is admissible against him, and I don't believe that it's admissible in normal cases against anyone else. In this circumstance, I also don't believe that it is. At this time, I don't believe the cases that I've read suggest that it would not be admissible against another defendant. That's
All right. I mean, I think that's generally correct. So I know I think I've mentioned before needing a limiting instruction. And I know we're not quite at that stage yet, but I don't know when you intend to introduce that. And,
not for the next 2 weeks, I believe.
okay, well, can you go ahead and be trying to put together whatever appropriate limiting instruction there would be? And then I would think that the position of both the defense and the state would be the same with regard to Mr. Ryan's murder jury verdict.
Right. Well, yeah, I know that the court, I know we addressed it last week, and I was saying that I was looking into that.
Mm-hmm.
So I don't have anything to counter the position that it's only admissible against Ryan. I don't have anything to
All
counter
right.
that position yet.
So we'd need a similar limiting instruction for that. Let me ask the defendants with regard to whatever information did come in on Mr. Winfrey having pled, that having been overturned somehow, and then him having pled again. There was no information in front of the jury that it was an Alford or a best interest plea.
That's true.
Okay. We've obviously introduced that concept to this jury at this point. Does the defense want me to instruct sometime at the end of the case that, hey, with regard to what you heard about Mr. Winfrey's plea, that was also a best interest plea, and so the same things apply?
Yes, and I intend to
Okay.
call the, in my case in chief, I updated my witness list. The
Okay.
lawyer at the first one, when it was coerced by the court, and that's why it wasn't knowingly, freely, and voluntarily given, and then call Mr. Sadow.
All right, well, I don't know that we're going to be doing all of that, because if it is before the jury that the other one was overruled, then the other one really doesn't need to be taken into consideration.
It was not before the jury. The other one's overruled. And please, we have to look at the transcript.
Okay.
But it was something to the effect of later, for whatever reason, a short while later, did he re-enter his guilty plea?
Okay, well, maybe we will get the necessary information to the jury without having to do it through a couple of witnesses. Maybe y'all could work on a stipulation. Why don't y'all make efforts to work on a stipulation that would cover that?
Also, Your Honor, there was the matter of the playing of Mr. Zachary's 2017 interview by Mr. Williams. Your Honor, if I am not mistaken, that the portions that were played included a reference by Mr. Zachary to the fact that Mr. Winfrey had entered that guilty plea. If I'm wrong, I accept that, but my memory is that from the time that it was first broached way back when, earlier this year in April or whenever it was, and now Defendant Williams actually introduced the fact of the guilty plea by Mr. Winfrey through cross-examination of one of the state's witnesses. In playing a video, the witness that was being interviewed actually talked about that guilty plea.
Well, that may be, but regardless, we need the correct information in front of the jury, so.
Can I just make a statement on that? Is that okay?
Yeah.
So I do believe that Mr. Zachary said that Mr. Winfrey pled guilty.
Uh-huh.
But, you know, to say that I somehow then introduced that concept, you know, I'm dealing with a fact that already came out before
It already
the jury.
came out, right.
So I don't think that
Okay,
holds much weight.
yeah, but I would like for y'all to try to figure out a stipulation that will cover what the situation was, and then I'll give an instruction about that having ultimately been a best interest plea.
Okay.
Okay.
When I say okay, I still intend to call the witnesses, but I will follow your direction.
Okay. Well, I mean, you know, if that's what's necessary, that's what's necessary, but I don't believe it should ultimately be necessary. I think there ought to be a stipulation that could be worked out, and if it's not a stipulation, then you can just propose what the stipulation would be, and I'll take it from there, maybe. Okay, all right.